Our Honorable Director General Mr. Uday Bhaskar and our President Dr. Jayanta could not able to join us, but they have extended their greetings for the today's program. And today we are pleased to have with us Mr. Devesh Malladi, the Chairman NDPS Committee IDNA, and Ms. Tripti Tandon, the practicing lawyer for NDPS Act, and Mr. Prasannan Nambudri, practicing lawyer and NDPS Act with us today. In today's program, we are going to have a key insights on the NDPS Act and the rules and the different kinds of substances and the authorities involved in the implementation of the Act and rules with regards to these different kinds of substances and the common misconception and misinterpretation. So to give a clear-cut insight for all the drug regulators on these aspects, I invite Mr. Devesh Malladi, Chairman for NDPS Committee of IDME. Before I hand over the stage to Mr. Devesh, I take the pleasure and privilege to introduce formally Mr. Devesh to the audience, though most of the audience are aware of Mr. Devesh, but it's a customary for me to give a formal introduction about Mr. Devesh. It's very happy to know that he's a pharma graduate from Delhi University and he pursued his master's in bioengineering technology from Andhra University. And he is one among the topper in his education, and he was selected on all India basis and sponsored by the British Council to undergo the scholarship program in UK. And he was awarded with the prestigious British Challenging Scholarship for the Young Managers by the Government of UK in 1997. He had 3 decades of experience in the production and sales of NDPS products across the 100 countries, and currently he is the Managing Director of MBO Labs. As a chairman of NDPS Committee of IDME, he has been closely associated with Department of Revenue and the Central Bureau of Narcotics and Narcotics Control Bureau on policy initiatives. With his contribution, he was actively involved in the making amendments to the NDPS Act in 2014 and also rationalizing the NDPS rules for the controlled substances, psychotropic substances, manufactured drugs, and essential narcotic drugs. Recognizing his tremendous expertise in this area, he was also nominated to the expert committee group on precursors and designer precursors constituted by the Ministry of Home Affairs. He was also nominated to an expert group committee by International Narcotics Control Bureau, Vietnam. With that brief intro, I take the pleasure to invite Mr. Devesh Malladi for his detailed talk. Pleasure to have you with us.
Thank you. Thank you very much for the kind introduction, Lakshmi. And firstly, I would like to place thanks to EDCOC for inviting me and finding me competent to talk on this complex and difficult subject, which is NDPS Act. Yes, it's true that I have 3 decades of experience in this space, but I guess every day is a learning. Yesterday evening, I learned a few things because I was preparing for the webinar. So I'm very privileged to be talking to this audience of drug regulatory officers from across the country. And I do hope this session would be interesting to all, and I hope it's not too technical and boring. At the end of the whole my presentation, I would like to invite Q&A questions on whatever you have. And I'm very glad that I have learned legal experts with me, both Tripti and Nambudri, to contribute on any legal interpretations of the Act or the rules thereof. So with these few words, I'm going to start my presentation. Can you see my screen? Lakshmi, can you see that?
Yes, Mr. Devesh.
Okay. Yeah, thank you very much. So the topic, I've tried to prepare this presentation based on my experience and interaction with drug regulatory officers from across the country, and also enforcement officers, not just drug regulatory officers, about NDPS, and I think I coined this particular title as to what should drug regulatory officers know about NDPS, what is relevant that they should really be aware in case of NDPS. I'm sure many of the drug regulatory officers know quite a bit about the interplay between Drugs and Cosmetics Act and the NDPS. But I would be dealing more about the NDPS today and specific provisions about the NDPS. So the audience should know that NDPS products has very large and wide applications. This slide talks about the wide-reaching applications that NDPS products have, essentially controlled substances, which are also called precursor chemicals in various chemical industries. As you can see this slide from fine chemicals, aromatic, automobile, agrochemicals, textile, flavoring, paints and dyes, plastics and explosives, and rubber products. So they have very wide-reaching legitimate applications. They also have a wide-reaching pharmaceutical applications, from psychological ailments treating depression, anxiety, addiction, common ailments such as headache, fever. When you say fever, paracetamol, you need acetic anhydride to manufacture that. Respiratory, cough, cold, allergy, asthma, pain management, a very, very important area. Terminal illnesses such as cancer, AIDS, accidents, post-surgical, agrochemicals, aromatics. Oh, did I? Okay, so there's a mix-up here. And life-limiting and debilitating diseases like dementia, heart, liver, etc. Some of the NDPS substances are listed in the National List of Essential Medicines. And it's very important to know that access to such medicines is of vital public health importance, besides being a matter of an individual's right to health under the Constitution. Now, the principle of balance, the WHO ensuring balance of national policies on controlled substances, it represents a dual obligation of governments, and this principle is enshrined in the International Drug Conventions. On one side, it is the obligation of the governments to establish a system of control that ensures adequate availability of narcotic drugs, psychotropic and controlled substances for medical and scientific purposes. At the same time, balance the prevention of abuse, diversion, trafficking in illicit drugs, and mitigate the diversion from legitimate to illegitimate channels. And this is a dual obligations that governments across the world are expected to do. And in line with the principle of balance, if you look at the object of the NDPS Act, which is Section 4, now the Section 4 says central government shall take all such measures for the purposes of blah, blah, blah. And prior to 2014, Section 4 stated prevention and combating abuse of illicit traffic in narcotic drugs. In 2014, Section 4 was amended to include and for ensuring their medical and scientific use. So the amendment of Section 4 in 2014 by the Parliament and by the central government makes it obligatory for the Government of India to maintain a balance between controls and ensuring availability for legitimate use. I would like to move to the international conventions and how the international conventions flow through the NDPS Act into the different categories. Now, the NDPS Act obviously has its origins in the United Nations conventions. There are 3 conventions. The first being the Single Convention on Narcotic Drugs of 1961. And in the NDPS Act, it is categorized as narcotic drugs. And there are 2 subcategories, which is manufactured drugs and essential narcotic drugs. The Convention on Psychotropic Substances of 1971, it flows through the NDPS Act as psychotropic substances. And the United Nations Convention Against Illicit Traffic in NDPS of 1988 flows through the NDPS Act as controlled substances. Now, the central government notifies or exempts a substance from the list of controlled substances, manufactured drugs and psychotropic substances, as per Section 2, 7D and 211 and Section 3 of the NDPS Act. Now, a brief overview of the nodal agencies under the NDPS Act. Uh, the NDPS Act is administered by Ministry of Finance, Department of Revenue. There are two agencies under Department of Revenue, the Central Bureau of Narcotics and the GOAF, which is constituted under Section 4 of the Act, and the Ministry of Home Affairs, under which the Narcotics Control Bureau is constituted as per Section 4 of the Act. The CBN main function is to grant licenses to farmers for cultivation of opium, monitoring, surveillance, law enforcement, collection of the opium to be handed over to GOF, and licenses for narcotic drugs, grant of quotas, registrations for psychotropic substances, and grant of import-export permits for NDPS products. The government opium alkaloid factory is responsible for processing opium to manufacture opioids such as morphine, codeine, thebaine, and other alkaloids, and also import of the same for any domestic sale in India. The NCB is only an enforcement agency which is tasked with combating drug trafficking and the use of illegal substances under the provisions of NDPS Act. However, in addition to that, all registration of controlled substances and filing of quarterly returns is also done with this particular authority. So this slide encaptures the overview of the nodal agencies prescribed under the Act. I have selected a few sections of the Act which are relevant for to be discussed. Section 8 actually prohibits certain operations such as manufacture, possession, storage, import, export, interstate, etc. of any narcotic or psychotropic substances, including cultivation of cannabis, except for it imposes a blanket prohibition except for medical or scientific purposes, and in the manner and to the extent provided by the provisions of the Act or rules or orders made thereunder. And in a case where any such provision imposes any such requirement, then it should be in the way of a license, permit, or authorization in accordance with the terms and conditions of such license, permit, or authorization. Now, this is the essence of the entire Act, where there exists a blanket prohibition except for medical and scientific purposes. And this is something which is very important for drug regulatory officers to understand, that yes, there are potential abuses of these products, but the exemption, the clear exemption under the law, is for medical and scientific purposes. Now, Section 9 of the Act empowers the central government to frame, to permit, control, and regulate and frame rules. The Section 10 does clearly stipulate as to powers of the state government which can permit, control, and regulate. And Section 70 of the Act actually directs both the central and the state governments to have regard to international conventions while making rules. I just discussed about the 3 conventions which flow through the NDPS Act into the different categories. So Section 70 clearly states that we need to have regard to international conventions. Section 80 of the Act, as per Section 80 of the Act, and this is important for drug regulatory officers, that the provisions or rules of the NDPS Act are in addition to the provisions and rules of the Drugs and Cosmetics Act 1940 and not in derogation of it. So both NDPS Act and Drugs and Cosmetics Act, where it involves drug substances, then there is a clear interplay between both the acts. But there are certain substances under the NDPS Act, like the controlled substances, which do not, and certain controlled substances do not fall as under the purview of the Drugs and Cosmetics Act, like solvents and chemicals like acetic anhydride and other products. Now, what are the different categories of substances under the NDPS Act? Now, the narcotic drugs has 2 subcategories, as I mentioned. The legal definition is manufactured drugs and essential narcotic drugs. Manufactured drugs, there are 124 substances, examples are thebaine, diphenoxylate, dextropropoxyphen, etc. Essential narcotic drugs, which was carved out of the manufactured drugs in 2014, has 6 substances, and these are the examples of the 6 substances listed under END. The second category is psychotropic substances, for 149. Even as late as day before yesterday, there was a notification of inclusion of further substances under this category. And common drug examples are products like alprazolam, petazosine, clonazepam, phenobarbital, buprenorphine, etc. And controlled substances, there are 23 substances in schedules A, B, C. And common examples are acetic anhydride, acetic ephedrine, and pseudoephedrine. Now, what are the authorities empowered under the NDPS Act for these different categories of drugs? For manufactured drugs, excluding ENDs, the rule-making authority is central and state government, because both of them have interplay, and I'll go into details in the further slides as to what is the interplay between central and the state. The licensing authority for manufactured drugs for APIs, the licensing authority is Central Bureau of Narcotics, Gwalior, and the state authorities for preparations as stipulated under the state NDPS rules. Now, in case of essential narcotic drugs, the rule-making authority is the central government, and the licensing authority is the state drug controllers. The psychotropic substances, the rule-making authority is the central government. The license is granted under the Drugs and Cosmetics Act, and there is a compulsory registration for all manufacturers and submission of returns to the Narcotics Commissioner. And in case of a controlled substance, again, the rule-making authority is the central government, and the registration of Schedule A substances is to be done with Narcotics Control Bureau, which is under the Ministry of Home Affairs. I would like to now move on to certain misconceptions and misinterpretations of the Act that I have seen over the years, interacting with various drug regulatory officers, even law enforcement officers. And as I mentioned, there are different categories of NDPS substances. And I'm sometimes amazed to see what is the perception of some of the drug regulatory officers and law enforcement officers towards this. And I would not say the common, there is a perception that all these are nashili dawa. There is only one word that is underplaying all this. NDPS Act products means there is a negative connotation in the minds that it is nashili dawa. Now, as I said, there is a lack of understanding of different categories under NDPS and why they are placed in a particular category. And I would just like to dwell a sentence on each of this category. Narcotic drugs refers to a category of which alters perception or sensory dulling drugs and which are addictive. Psychotropic substances are substances such as psychoactive stimulants. They do have a psychoactive effect, and psychedelics, which are habit forming. And controlled substances are precursor chemicals, which are raw materials for manufacture of substance of abuse, but they themselves do not have addictive, euphoric, or habit-forming properties. This is very important for drug regulatory officers to understand, that there is a purpose and reason for each of these categories and why the controls are different, the licensing requirements are different, the compliance are different for each of these category of substances. Moving on to other misconceptions that I have come across. This is a very controversial product. I'm sure all of you would have different views on this, that codeine cough syrup is under the purview of NDPS Act. But actually, if you look at Section 2, the central government, by a notification in the official gazette, they can declare a product not to be a manufactured drug. They can provide an exemption, and they have given an exemption for codeine preparations in the list of manufactured drugs at entry number 35. And what does that entry say? It is also the same exemption that is provided under Rule 52A of the NDPS Act, which specifies that codeine preparations containing not more than 100 milligrams of the drug per dosage unit and with a concentration of not more than 2.5% in undivided preparations is outside the purview of the NDPS Act. And this exemption, please kindly appreciate and understand, is not just specific to India. It flows from the conventions. There are many such manufactured drugs, which there is the conventions have provided exemptions because of the fact that in that particular dosage form, it does not have addictive properties, or the potential of abuse is not as much as the substance itself. And that's the reason and the purpose of the exemption. And these exemptions flow from the conventions. Now, the second misconception is ephedrine and pseudoephedrine should be banned. Many of the drug regulatory officers have this view because of the issues as nashili dawa, which is wrong. And as I mentioned before, these are precursor chemicals for the manufacture of methamphetamine, which is a substance of abuse. And by itself, and kindly note, by itself does not have addictive, psychoactive, or habit-forming properties. It is the most effective and popular nasal decongestant in the world in combination with anti-allergy drugs. There is no effective substitute for a decongestant like pseudoephedrine in the world. And from a legal standpoint, the formulations are outside the purview of NDPS Act, except in the case of import and export, where an NOC from Central Bureau of Narcotics is required. Now, another very important misconception is that isomers and derivatives of psychotropic and controlled substances are included in the NDPS Act and its schedules. Many of the show cause notices that I've seen talk about an isomer or a derivative, and then the interpretation is that it comes under the purview of NDPS Act. And I think the drug regulatory officers should have the ability to distinguish and rightly distinguish as to what is right interpretation of the Act, whether an isomer and derivative is construed as part of the NDPS Act. If you look at the definition of psychotropic substances under Schedule 223, subsection 23 and section 3, and the schedule to the Act at entry number 111, it only specifies salts and preparations of the above. And if you look at Schedule A, B, C of the RCS Order 2013, it again clearly specifies salts and preparation, and for certain substances only again. It's not for the entire list. Now, for example, diephedrine is an isomer of ephedrine. It is not ephedrine by itself. Same is the case here with DL-ephedrine. And for example, paracetamol and aspirin, in reality, it is a derivative of acetic anhydride. Just because it's a derivative doesn't make it a NDPS product, because paracetamol and aspirin do not have addictive or psychoactive properties. So I guess it is very important. This is a very important slide for drug regulatory officers to absorb and appreciate the distinction between salts and preparations and isomers and derivatives of NDPS products. Now, this is a very interesting example I wanted to show. This is an actual NDPS license granted by one of the state authorities, a misinterpretation of the NDPS Act. And a typical example, the product at the end, as you can see, is sodium barbitol. It's a psychotropic substance. And the state licensing authority here, as you can see, it's dated 2015, and they have granted an NDPS 1 license, which is actually meant for a manufactured drug. Now, obviously, there is a misinterpretation of the Act or inability to understand the provisions and the different categories of the Act, which led to the company which even applied for such a license, and also the regulatory, the state FDA authority to grant such an NDPS 1 license. So this is an example which I want to highlight, that it is very important for the drug regulatory officers to really understand the different categories and the sharp understanding of the categories, and not misinterpret it in any way, because this has far-reaching implications, and including availability of such substances for maintaining the health of patients. So this is an example of incorrect categorization. And again, recently very active subject in the world and India is cultivation of cannabis is prohibited and illegal under the NDPS Act. Actually, the answer is incorrect. Section 8, read with Section 10 of the Act, actually permits cultivation of cannabis for medical and scientific purposes. And if you also go into section 14 of the NDPS Act, it permits cultivation for industrial purposes for obtaining fiber or seed for horticultural purposes. Internationally, it's called hemp. Now, coming to certain misinterpretations on essential narcotic drugs. Now, I've heard, of course, the amendment happened only in 2014. The rules for essential narcotic drugs were only published and gazetted in May 2015. And there was a conference organized by the ministry in Delhi for all the state drug controllers and CDSU officials. And I was very amazed to hear some of the comments that came out. And later on, many of the state regulatory officers very strongly believe in these statements that no, ENDs are still under the purview of state NDPS rules. Or they say that, oh, you know what, we need to get the go-ahead of the chief minister to implement such rules, although it's clearly gazetted and specified by the central government under Chapter 5A. Or some of the states believe that the state NDPS rules need such amendments. I would like to point out to the attention of all the drug regulatory officers here, saying that the section 9 of the NDPS Act is very clear. It provides that where in respect of an END, the state government had granted or permitted license under provisions of section 10 prior to the commencement of this amendment, such license or permit shall continue for a period of 12 months from such commencement or till its validity, whichever is earlier, which clearly states that the powers that were granted under section N, which is the second bullet point, for possession, transport, purchase, sale, import, export, use and consumption, all that which was there under the state NDPS rules, that power to frame rules has been withdrawn and included in section 9, which the central government has the power to regulate, and hence the state NDPS rules governing the essential narcotic drug products is redundant and invalid because of the amendment which was passed by the parliament in 2014 and the rules pertaining essential narcotic drugs being gazetted in May 2015. I'm going to talk more specifically about essential narcotic drugs a little later on, because it's very important to understand, because essential narcotic drugs have a very important role to play in pain relief for terminally ill illnesses. Okay, so I'm going into that now. The narcotic drugs, I've completed my brief presentation on misconceptions and misinterpretations. So the narcotic drugs as defined under section 2, they include coca leaf, cannabis, hemp, opium poppy straw, all manufactured drugs and all essential narcotic drugs. Now, keeping in line with the 2014 amendment, the object of the Act, which was amended to ensure availability of NDPS for medical and scientific purposes, a new category was defined under section 2 called essential narcotic drugs, which was carved out from the list of manufactured drugs to ensure its easy availability for palliative care. And what was the need to carve out from the manufactured drug? I will come to that in the next slide. But these are the 6 substances to begin with. But please kindly note that the central government can notify any drug as END under section 2 of the NDPS Act. So far, only 6 substances have been notified, but in the future, there could be more based on its medical and scientific use. So the 6 substances are morphine, codeine, oxycodone, hydrocodone, methadone, and fentanyl. Oxycodone and hydrocodone are drug products which are still not approved in India by DCGI. Now, what was the need to carve out? If you look at the old procedures for manufactured drugs, and all manufactured drugs still have these procedures. The old procedures, you needed multiple licenses from each state authority, multiple agencies involved. In Maharashtra, it would be the state drug controller granting a license. In Gujarat, it would be the excise authority. In some other state, it would be the collector. And there were different validity periods for each of the licenses to be obtained in the individual states. And there were different rules in different states. And there was a need for transport permit. Every consignment had to be, you needed to get a transport permit from a specific designated authority as stated in the state NDPS rules. What was happening? India, as a country having 29 states, we had 29 different set of rules governing movement of an extremely critical product such as morphine and codeine. And as a result of this, and everybody, this audience should know that when the Act was implemented in 1985 with all these procedures, by 1997, the consumption of morphine in this country has reduced by 97% prior to 1985. Even today, if you look at the population of close to 1.5 to 2 million cancer patients in this country, and 70 to 80% of them need pain management. All of you would be surprised to know, sir, that, and ladies and gentlemen, that only 3 to 4% actually receive pain management. There's a whole generation of patients in this country suffering from pain for terminally illnesses. Actually, they've taken it for granted. Cancer aayega to extreme pain aayega. A lot of patients actually commit suicide, not because of cancer, because of the fact that they're having pain. And what is the fundamental reason? Because of our self-defeating laws and procedures that we have. And what did the 2014 amendment do? The intent of the 2014 was on the right-hand side, the rules pertaining to possession, transport, import, everything was simplified for END under a section called Chapter 5A. I will not get into the detailed rules. What it did, it had uniform rules for all the 29 states and union territories. There's a single licensing authority nominated under these rules, that is the state drug controller, and how he issues the license, in what forms he issues the license, whether it is for possession, storage, or for a registered medical practitioner or an institution. Everything is prescribed in these particular rules. Now, there are simplified rules for medical institutions for possessing, dispensing, and selling essential narcotic drugs. There was an RMI certificate format has been included, where it is valid for 3 years and can be renewed easily. And they have done away with either you can move the products, transport the products with a simple consignment note, which is prescribed under Rule 52D, or just a sale bill or an invoice or a cash memo with details as specified under Rule 52D, Sub-Rule 3. If it is as per that, then you can just move essential narcotic drugs from one state to the other state, from Maharashtra to Bengal, from Kashmir to Tamil Nadu, without the need for multiple procedures that are there in the old procedures. And I guess the drug regulatory officers and the law enforcement authorities in this country should understand that we are talking about the health of patients. We are talking about our responsibility to deliver pain management drugs to patients who are suffering. If you have ever seen a patient in the terminal illnesses of cancer, if you see them wriggling with pain, one would really wonder, why is it that these drugs are not available everywhere? And the reason is because of that. But have things changed between 2015 and 2021? The answer is no. And I'll tell you why a couple of slides later on. But it's a big amendment. It's a big move. It's important for drug regulatory officers to understand the intent of the 2014 amendment, and not only intent, going forward, it is important that everyone should come together to ensure one simple objective. Can we deliver a medicine to a patient in need without putting in unnecessary regulatory hurdles and rules and regulations? That's important. What is important is to ensure meeting the objective of meeting the healthcare needs of the country. But at the same time, I'm not advocating that the controls should be set aside, not at all. But I guess the amendments that have happened should be agreed upon uniformly, and there should not be resistance, because this is gazetted and this is done by the central government. There's no reason for state governments to say, no, 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 we will not comply with this. There are, even today, there are state governments which are saying, no, no, you go to the excise. This is the old procedure, and that is not required anymore. Okay, so I'm getting into a little specific. I will quickly move from this slide because I'm sure the presentation would be circulated to everybody. But I'm talking about manufactured drug. What is the relevant rule under the NDPS Act, and who's the licensing authority? If you can see the slide, you will see the manufacturer is a license is given by CBN. The manufacturer of preparations is under state NDPS rules. Possession, transport, sale is under state NDPS rules. Record keeping, again, for the API, it's to the NC. CBN, manufacture preparation, state NDPS rules. Destruction, again, you have to go to multiple authorities. So, there's a bit of a maze that exists where it's very confusing even for industry, even for enforcement officers, even for drug regulatory officers, that for what category, where do we go? Again, within the category, between API and preparations, why should there be multiple authorities and multiple rules? And the moment you go to state NDPS rules, no two states have the same NDPS state rules. So hence there's tremendous amount of confusion in terms of possession, transport, sale, and these sort of provisions. Now, how has this moved to END? When the END rules came out in 2015, and of course, I was very closely involved in the drafting of the rules, but I must say that there were lacunas in the 2015 rules that were framed under Section 5A. Now, again, what are the lacunas? If you see, preparations have still been kept under state NDPS rules. There's a reference under Rule 37. Now, same in case of record keeping, because of the fact that preparations under Rule 37 comes under state NDPS rules. Now, there's a legal interpretation here, I must say, that if you see the Gazette of Essential Narcotic Drugs, the Gazette says essential narcotic drugs includes the API and its preparation. So a definition of END under Section 2, actually the legal interpretation is that it includes the API and the preparations. That's the Gazette notification. That being the case, the rule, which is Rule 37, talks about preparations is the grant of license would be done referred to Section 10. So in a way, it ultraviolates the Act. In fact, this has been brought to the notice of the ministry, and there's an amendment that's been asked that the preparations, the rules for the preparations have to be prescribed under Section 5A, and it cannot be referred back to Section 10 because it defeats the very purpose of the amendment of 2014, where the powers to regulate have been taken out from Section 10 and brought into Section 9. So the moment it's brought out of the purview of Section 10, the power to regulate and frame rules for END does not lie with the state authorities and the state NDPS rules. And rightly so, if you look at the intent of this particular amendment, the intent is to ensure smooth manufacture, possession, transport, sale. But there are clear administrative requirements of how you need to do that. The intent is to ensure that the availability is there across the country so that patients get access to these extremely essential drugs across the country. And it's my humble plea at this moment to all drug regulatory authorities who are actually listening to this, that their cooperation is required in the right interpretation of the different provisions of the NDPS Act with regard to essential narcotic drugs, and ensure that no impediments from unnecessary impediments are created to ensure availability, possession, transport, and sale of these substances. At the same time, I'm not advocating any letting up of any controls and compliances as required by the law. In case of psychotropic substances, it's much more simpler. The manufacture of API and preparations and sale, possession, transport, all of them is as per the Drugs and Cosmetic Rules 1945. These are the specific relevant rules. But in addition to the licenses and required under the Drugs and Cosmetic Rules, one is the manufacturer is required to register and file returns with Central Bureau of Narcotics. And even the destruction is as stipulated under the Drugs and Cosmetic Rules. I've seen in many states, oh, psychotropic substances hai. नहीं, ये तो narcotic substance है, आप CBN के पास जाइए. And then somebody is going to CBN and CBN says that no, we are not the authority to do it, and it gets lost in the whole maze of wrong interpretation of what is required for destruction of a psychotropic substance. So these three slides actually clearly stipulate as to who's responsible for what. I'm talking of the major aspects that drug regulatory officers should really know about. And then the controlled substances, as I mentioned, precursor chemicals. One needs to obtain a unique registration number for Schedule A substances, and this is only for Schedule A substances and not for Schedule B and Schedule C. And the licensing authority is Zonal Director NCB. The transport sale of Schedule A substances, there's no license required, but for exports, you need to get a export or import license from Central Bureau of Narcotics. But for case of transport, you need to have a consignment note as prescribed under clause 7 and 8. Destruction, again, the authority which gives the permission for destruction or the application to whom it should be made is the Zonal Director, Narcotics Control Board. Now, this is just the 4 slides is basically specifics about what the rule says, the relevant rule and the licensing authority, just to give a perspective. And here, I just want to pause for some water. Good, I think we're doing good on time. I just have a few slides more. I want to move on to a very important subject of today's important, and the purpose of bringing up this particular slide is to sensitize and make aware for everybody as to what's happening on cannabis, its medical use, what is the legal status of this particular category of substances. And going forward, the whole intent is just to sensitize. I'm not putting forth any opinion. It's for the drug regulatory officers and the law enforcement and the policymakers to take a decision as to where India wants to go as far as cannabis and marijuana is concerned. But my intent is to bring to the forefront the laws governing cannabis in this country and what's happening around this particular thing. So let us go to what is the definitions under the NDPS Act for cannabis. If you look at section 2 of the Act, cannabis hemp is defined as follows. It's defined as charas, which is the separated resin obtained from the cannabis plant, also including concentrated preparations and resin known as hashish, oil or liquid hashish. Ganja, this is the flowering or the fruiting top of the cannabis plant, and it excludes seeds and leaves when not accompanied by the tops, and any mixture with or without any neutral material of any of the above forms of cannabis or any drink prepared thereupon. So the legal definition under the NDPS Act is ABC. Now, under section 2, subsection 4 of the Act, cannabis plant means any plant of the genus cannabis. And there's a further definition under the Act and the definitions which defines medicinal cannabis, which is a medicinal hemp means any extract or tincture of cannabis hemp. So there is a clear definition of medicinal cannabis, which means the intent of the Act in 1985 was that there was a medicinal use of cannabis. So that with that intent, this particular definition was put forth in 1985. Now, under the Act, section 10 of the Act empowers the state governments to permit and regulate cultivation, production, manufacture, possession, transport, import and export interstate, sale interstate, purchase, consumption, or use of cannabis, excluding charas, provided that the cultivators deliver all the product to the state government. And Section 14 of the Act further permits the cultivation of the cannabis plant for industrial purposes, for obtaining fiber or seeds for horticulture purposes. So these are the legal provisions under the NDPS Act pertaining to cannabis. Now, I put a picture of the plant just for to educate everybody, to make aware. If you look at the top part of the plant, which is the flower and the fruit, this is where you get charas and ganja from. It has high THC and CBD content. THC is tetrahydrocannabinol, which this is the ingredient or in cannabis, which actually gives you the euphoric effect. And CBD is the substance which does not give any euphoric or addictive properties. This is the medicinal cannabis is actually obtained from the flowering top. Now, you also have low THC and CBD strain varieties of the cannabis plant, which is called hemp international. Now, the leaves of the cannabis plant is also called bhang. It has very little THC and CBD. It is not that it doesn't have. And of course, it's used in festivals such as Holi, which is coming up in the next couple of days. Happy Holi to all of you in advance. And bhang and the leaves of the cannabis plant is exempt from the NDPS Act. Now, what is hemp? Hemp internationally across the world is used for industrial purposes such as fiber, for textiles, construction, polymer industry. It has applications. It is used in textiles. It is used in polymer industry. It's an excellent, strong construction material. So this is just to give you a pictorial view of the different parts of the plant and what it contains and what is the cannabis plant. Now, what is medicinal cannabis? Now, as I said, it's the flower of the cannabis plant, and to treat diseases or conditions as approved by a country's drug regulatory authority. Now, the flower in measured quantities is allowed to be prescribed in many countries. And these are the list of countries, and there are many more. I've actually captured only the countries where of importance around the world, where there is a clear medicinal cannabis program for specific disease indications. And countries have separate medicinal cannabis authorities, which actually monitor, control, and regulate the movement and dispensing of medicinal cannabis across the country, across their countries. Now, these are the disease indications for which medicinal cannabis is approved across the world. I'm not going to go into the details, too much details of this slide, but the mota, we're talking about chronic pain, we're talking of multiple sclerosis, nausea, vomiting, appetite, the Giles syndrome, glaucoma, and other indications such as cancer. There's so much of research and clinical trials happening across the world for cancer, epilepsy, inflammatory, Parkinson's disease, and other psychiatric disorders. Now, this is basically to make aware as to the benefits. Excuse me. To make aware benefits of medicinal cannabis to the audience here. Now we'll move on to the legal status of cannabis in India as per the NDPS Act. Now, as I mentioned, cannabis, hemp, including flowering top, and medicinal cannabis includes extracts, is defined as a narcotic drug, again defined as a manufactured drug, and cannabis, its extracts and tinctures appears as a Schedule 1 narcotic drug. What does it mean? It means that import and export of Schedule 1 narcotic drug is prohibited except for research and analytical purposes. But for cultivation, possession, sale, use, consumption within the country, it is legal. Please try to understand there's no prohibition under the NDPS Act for these operations of Cannabis Act, cannabis in terms of cultivation, possession, and other operations. Now, Cultivation of cannabis planned for medicinal purposes, state governments, I mentioned under Section 10, are empowered to permit and regulate cultivation. Out of the 29 states and 7 union territories, only 3 states have actually framed rules for cultivation of cannabis, which is Uttarakhand, Himachal, and Haryana. Now, many of the states, and I'm going to talk in the next slide, some of the states have a detailed chapter, state NDPS rules on cannabis, and I'll come to that. However, cultivation of cannabis for medicinal purposes is currently, in reality, it's only permitted by certain states for research and analytical purposes. And on the right-hand side, if you see cultivation of cannabis plant for industrial purposes, it's allowed for seed, fiber, and horticulture purposes. And to be very clear, the leaves, which is bhang, and seeds of the cannabis plant are outside the purview of NDPS Act 1985. It's absolutely clear as far as the legal status of the leaves and the bhang, which is called bhang, with respect to the NDPS Act. Now, other important points to know, a number of states, if you look at the state NDPS rules of Andhra, Maharashtra, Rajasthan, Orissa, Haryana, they have specific chapters on cannabis in their respective NDPS rules, which actually permits registered medical practitioners and patients to possess, use, and consume ganja for medical purposes. This is very, very interesting and important to note. Other states also provide for a general reference to manufactured drug, which in turn actually, by definition, manufactured drug, medicinal cannabis is a manufactured drug under Section 2. So if there is a general reference to manufactured drug under other state NDPS rules, in turn, it also applies to medicinal cannabis. So the state NDPS rules have clear provisions for use of cannabis for medicinal purposes. And if you look at Schedule E1 of the Drugs and Cosmetic Rules, which is to do with Ayurvedic, Siddha and Unani, products like bhang, charas, and ganja are included in Schedule E1. If you look at Ayurvedic, there's a specific reference to bhang, Siddha has specific reference to ganja, and Unani medicines has specific reference to charas. And in addition, entry number 346 under Schedule H states narcotic drugs listed in NDPS Act. And I mentioned before in the previous slides that cannabis is a narcotic drug. It is a manufactured drug and hence a narcotic drug. So by virtue of this particular interpretation, cannabis is part of the entry 346 of under Schedule H. Of course, the medicinal cannabis is not approved as an allopathy drug in India as yet, as we speak today. But I just want to bring it to the forefront that cannabis, by virtue of the fact that it is a narcotic drug, is a Schedule H drug as per the entry number 346. And hence it is permitted if there is if the DCGI approves the medicinal use of cannabis, then it is permitted under the DCR rules because of the Schedule H entry. Now, I'm more or less done with my presentation. I'm going to stop sharing this screen. I wanted to end this presentation with a very nice, touching video. And I would like to end this presentation. Just give me a minute. I'll put on the video. Okay, we're ready to play. Just let me know if you're not able to see or hear the video.
He used just a single drop, and his hands afterwards were rock steady, and the dyskinesia left.
From animal experiments, we also know that boosting certain branches of the endocannabinoid system is helpful in relieving symptoms of Parkinson's. It's a plant that has a chemical in it, and this chemical does some good things and does some bad things. And the good things we appreciate, and the bad things we try to avoid.
Okay, so I would like to end the presentation with this video, which I thought personally was a very touching video. It's basically all of you are. Okay, I think the video is still playing. Let me just. And I study how stress affects the brain. Now, most of the stress that we face as regular people on a regular day-to-day basis. Okay. So I want to end this video with end this particular webinar with this particular video. It's basically to sensitize all of you as to what could be the future of cannabis, and what is it that we as responsible citizens, we as responsible drug regulatory officers, where is it that we need to move? What is it that we need to do? Because end of the day, the responsibility of ensuring the health of the nation is all in your hands. And it is you who determine as to what is it that you want for the nation, for your own elderly citizens who are suffering from certain diseases. With this note, I would like to end this particular presentation. I really thank for giving me this opportunity to make a presentation. I hope it was useful. And me and my and Tripti and Nambudri are very happy to take any questions that people may have. Thank you very much once again.
Thank you very much, Mr. Devesh. That was an excellent presentation giving an overview of the entire NDPS Act. And in fact, it has opened up the general wrong interpretation of most of our regulators as well. And the bottom line that you have given and ended the presentation is the with the video, he is really touched upon the hearts of all the audience. Now we'll be moving on to the question and answer session, and we could see a couple of questions in the Q&A chat. Of course, it's more of a mix of Drugs and Cosmetics Act and the NDPS Act, and the correct interpretation of the case of this act. There is a scenario of where the sale of the narcotic drugs happened in a licensed pharmaceutical premises. The licensee chemist has found possession of a narcotic drugs and is not able to produce a proper sale purchases or sale record of the said drug. In such cases, what is the NDPS Act or BNC Act? Which action to be taken under which act?
Since it's to do with a specific law enforcement, I would possibly ask either Nambudri or Tripti to answer this.
Should I go
Tripti?
ahead?
Yeah, please.
So I see that there are two related questions. The first is where there is the chemist is licensed, but when asked to produce the records, the records are not adequate. And the second is where there is no license in the first place. So as you're aware, Devesh pointed out, Section 80 of the NDPS Act says that it applies in addition to the Drugs and Cosmetics Act and not in derogation, which means that both acts have to apply in the case where the substance is either a narcotic or a psychotropic substance, or a controlled substance if the controlled substance is under the Drugs and Cosmetics Act and rules. Now, and there are two decisions of the Supreme Court, 3-judge bench decisions. Maybe some of you are aware. There's Union of India versus Sanjeev Deshpande, and a more recent one of State of Punjab versus Rakesh Kumar, where the Supreme Court has made it very clear that just because it is an NDPS drug, it doesn't mean that only NDPS will apply, or just because it's a scheduled drug, Schedule H or H1 or even X, doesn't mean that NDPS will not apply. So both apply, but I think the nuance is to be noted, because your first scenario is where the person has a license. So it is not unauthorized possession, it is licensed possession, but they're not able to produce the adequate records. So in my humble submission, the provision to apply would be drugs and cosmetics, as well as section 26 of the NDPS Act, which is a very least known provision, but of vital importance, because it talks about licensed entities and their agents. So if you could just allow me to read out this provision. It says that if the holder of any license or permit or authorization granted under this act, or their anybody who's their employee does not maintain accounts without reasonable cause, fails to produce without reasonable cause such license, permit, authorization, keeps any account or makes statements which is false, or willfully or knowingly does any act in breach of the conditions, then the punishment extends up to 3 years. So in my opinion, in the first case, where it is a licensed person but perhaps can't produce adequate records, this would be the appropriate section under NDPS Act, in addition to relevant sections of the Drugs and Cosmetics Act. In the second scenario, where the person has no license at all, then of course it is unauthorized possession, and there the relevant provisions of the NDPS Act, depending on whether it's section 21 or 22, narcotic or psychotropic, those would apply in addition to Drugs and Cosmetics Act.
I fully agree with what Tripti has stated. The position that section 80 would come into play here in a situation where the person from whose possession this particular narcotic drug has been found is also a registered person, also a license holder under the NDPS Act. And since the narcotic drug being covered under the Drugs and Cosmetics Act also, section 80 would come into play. And this situation has been very clearly brought out in Sanjeev Deshpande, as well as reiterated in State of Punjab versus Rakesh Kumar, where the future Chief Justice of India was also a member. And in that judgment, it has been clearly brought out that the provisions of Drugs and Cosmetics Act and NDPS Act both will coexist, and neither of the provisions will override each other, and both will apply in the first situation in the question before us. And what, like Trutya stated, in the second situation, since the person from whose possession this particular drug was found was not a license holder, only the provisions of NDPS Act will apply. Thank you.
Thanks for the detailed clarification on those two scenarios. Moving on to the next question. Whether the controlled substances for personal use in a small quantities for the export or import needs to get a license from the CBN.
Yeah, I'll answer that.
Please, Devish.
So any controlled substance, whether it's 1 milligram or it's this one, has to have a permission for export by Central Bureau of Narcotics, except for the fact if the said is a drug that, and it is for there's a prescription for that, then that is not required. But otherwise, of a bulk controlled substance in bulk form, or if it's a dosage form of Ephedrine Pseudoephedrine, which is exported in a commercial quantities, definitely needs NOC permit from Central Bureau of Narcotics.
here the question itself seems not so clear. They are mentioning it as a personal use. So, I mean, can we assume
Yeah,
that
personal use.
they're,
Yeah, it's with
they're
the prescription.
carrying,
Yeah.
personal use with prescription might not require the.
So if you look at the controlled substances,
May I
only
just
ephedrine. Yeah. Yes, sir.
what you're saying is appears to be right, and that's what I thought until I very closely looked at the RCS order of 2013, and this seems to be an anomaly here, where the order number 4 actually categorically also includes consumption of any controlled substance. I think this is a very serious anomaly because patients are not, you can't possibly expect patients with cold cough to get a registration from the NCB before they can consume the substance. I think there's a bit of a broad brush that has inadvertently happened, and maybe we should bring this to the notice of the authority.
May I just interrupt here? Clause 4 of the NDPS RCS order concerns only Schedule A to the NDPS RCS order. If NDPS RCS order schedule is looked into, it can be seen that only the bare APIs or the bare bulk chemical is covered therein, not the preparations. Clause 4, which requires registration, applies to only Schedule A to the NDPS RCS order, and NDPS RCS order Schedule A only covers the bulk, whether it is an API or a chemical, like anthrenic acid, N-acetyl-anthrenic acid, ephedrine and its salts, pseudoephedrine and its salts, then acetic anhydride, and the 2 lately added controlled substances which have been from the Schedule B and C. It is now also appearing in Schedule A, which are the precursors for manufacture of fentanyl. So if you look at all the 7 controlled substances which are appearing in Schedule A, you will find that none of the entries in Schedule A covers preparations. They are all bulk, either in API form or in chemical form. Having said that, Clause 4 will not come into play, but in the case of exports and imports, unfortunately, I would agree to what Tripti is saying, not in relation to Clause 4, but in terms of obtaining of NOC. The entries, let us take the example of ephedrine and pseudoephedrine. Entry what is appearing in Schedule A is different from what is appearing in Schedule B and C. In Schedule A, as far as ephedrine is concerned, the entry is ephedrine and its salts. But when it comes to Schedule B and C, it talks about ephedrine, its salts, and preparations. So if there is a case where a person, he is traveling out of India and he is carrying some ephedrine tablets, or he is coming into India and he is found carrying some pseudoephedrine tablets in his bag for his personal use or consumption, there can be a possibility that he can be stopped and he would be asked whether you are having an appropriate NOC from the Central Bureau of Narcotics. I am just reiterating the situation of law. I am not saying practically it would happen, but this is a situation of law.
I would like to add here that, one is the legal interpretation of the law, but I guess it is the discretion of the officer to always distinguish between the intent. The intent of the law is to ensure there is no diversion or illicit trafficking or illegal use. That's the intent of the NDPS Act, and not only in India, across the world. And it is the responsibility of the officer to ensure that the end use is genuine. And if it is so, the discretion should be used. And we should not use the interpretation of the law to really, to make it otherwise and in a way defeat the purpose object of the Act in terms of availability, whether it's ephedrine, pseudoephedrine, or any other products. I think the intent of it should be looked by the officer rather than pure complete interpretation of the rules, and that would be my opinion on this particular
make
matter.
it difficult for enforcement. Basically, what you want to say is, Devesh sir, is that one should not make it difficult for enforcement itself.
So for the
Right,
time being, if
right.
we keep the legal provisions and the officer's perspective aside, what would be the advice all of you to give to a patient who will be carrying that kind of a product that they intend to carry while traveling in and out of the country? So what is the advice that you wanted to give to those concerned patients? Whether they should go ahead with the NOC to the agency, or should they easily carry with the prescription, with the valid prescription in their hand?
It would all depends on facts of the case. If it is small quantity, then the officers would certainly ignore that. But under the garb of personal use, people cannot carry. Because I remember when I was a drug inspector, there were about 45 physician samples were found, and his explanation was it was personal use. Then I told my boss that he should be excused because he's suffering from 45 diseases.
Too many diseases.
All right, sir. Moving on to the next question. It's a simple, straight question: that does CBD oil falls under the purview of NDPS Act?
I would
Mr.
request
David?
Devesh sir to address this.
So it's a very highly debated subject at the moment at the policy levels. I think everybody should understand that the WHO, in its 44th report submitted to the CND last year, they've clearly stated that CBD has multiple medicinal use. It has no psychoactive properties. It has no addictive properties. It has very clear medicinal benefit. And the first drug based on CBD was approved in July 2018 in the United States for a very rare form of epileptic disease. And as we speak, there are 50 clinical trials across the world happening for various disease indications based on CBD. Now, the question of whether CBD, now, as you know, Section 14 allows for industrial hemp and for cultivation for industrial purposes. Now, when cultivation is allowed, there is an interpretation that I will give two interpretations. One is leaves of the cannabis plant also have CBD content. So if somebody is extracting cannabis oil, CBD oil from the leaf, it's outside the purview of NDPS Act. So that's a very important point to note. Second is the Section 14, and the industrial hemp is grown not in India, but in Western countries. Huge amount of hemp is grown. The definition of hemp is totally different in Western countries, and it's outside the purview of their local laws. Like in the United States, the Farm Bill was approved in October 2018, and there is huge amount of cultivation of hemp, which does not have THC more than 0.2%. Now, if you extract CBD from that and oil from that, it is absolutely legal. There should not be an issue there. I hope it answers the question that it depends on from where the CBD oil is actually coming from. It is from the leaves, or is it from the hemp, which is grown for industrial purposes under Section 14 in India, or internationally if it's grown legally and oil is coming from there, it's absolutely legal.
So ideally, we should look at the source from where this CBD oil is getting from. And there is another question from Pratish Sharma, the manufacturer. How do we handle the investigations on misinterpretation, like in the case of Codeine? And what are the precautions that I should take as a manufacturer and distributor? The second question is, will I also be liable for the wholesaler's violation?
Sorry, what's the second question?
He is a manufacturer. Is he also liable for the violation made by the distributor of that product?
How do I handle investigation is something I would not like to get into in this webinar. In terms of obviously compliance of all the records and as stipulated is very important.
Since his question is more related to the codeine related, where there is a lot of misinterpretation happening in the case of codeine manufacture and sale. In that case, if a dealer is dealing if he is dealing with some kind of a violations as a manufacturer, he is also liable or not?
No, not exactly. And I don't know, Tripti, would you like to add here?
Yeah, I think as Devesh pointed out, for codeine, certain preparations are clearly exempt from the NDPS Act because they are not manufactured drugs on account of the very minimal amount of codeine in it. But at the same time, there are decisions of our courts which maybe the court in that case was not fully made aware of the legal provisions or the fact situation was such. There is a decision of the Allahabad High Court where it was a person from a pharmaceutical company who had been arrested under the NDPS Act and was being prosecuted for codeine. And in his case, the Allahabad High Court quashed the proceedings by noting that codeine is exempt. And this is a person from a pharmaceutical company. He has all the paperwork in place, and it is authorized. There was another separate case which was before the Supreme Court. This is in 2010, where it was clearly a case of unauthorized codeine possession. These were the people were truck drivers and they were carrying a large consignment of codeine bottles, I think, across the border. And in that case, they tried to argue that codeine is exempt, so therefore NDPS Act should not apply. But the Supreme Court interpreted the provision to say that it is exempt only if it is for a therapeutic purpose. And since in your case, you are just carrying it to illegally transport it across the border, the therapeutic purpose parameter is not met, and therefore the NDPS Act would apply. So this is where we stand. But in my opinion, there is a certain nuance and complexity which perhaps requires further attention and discussion, because if the substance codeine preparation has been made exempt because it is purely a therapeutic drug. So it is not that the therapeutic purpose must come in the facts of the case. I think the foundational question is whether this drug is under the NDPS Act or not, whether this particular product is under the NDPS Act or not. And there, I think, there is room to kind of relook at the two decisions, but I'm going to stop here.
I would like to add here, Tripti referred to a 2010 judgment. In addition to that, I don't know whether it is the same judgment, but in Mohammad Shahabuddin versus State of Assam, Supreme Court has reiterated this fact that if the codeine cough syrup is being distributed through legitimate channels, means from the manufacturer to distributor and distributor, then to the wholesaler and to the retailer, and retailer giving it to the patients, in that situation, this product will be kept out of the NDPS Act. But the moment this product leaves the licit channel and goes to the illegal channels, it would come back to the NDPS Act. The NDPS Act would apply to this situation, and whoever are indulging in the illegal diversion of this particular substance can be charged and prosecuted under the NDPS Act. That is what has been held by Mohammad Shahabuddin. But I fully agree with Tripti that the intent of the manufactured drug notification, whereby this particular product is declared to be a manufactured drug only if it is above a particular limit. If the content of that drug in undivided dosage form or in the preparation, if it is above a particular limit, only then it becomes a manufactured drug. And if it is below the limit, it is not a manufactured drug. Doesn't mean that the fact that whether it is a manufactured drug or not needs to be checked from the end use point of view. That is not the issue. That is not the case here. In fact, Supreme Court went into the issue. Even the high courts have gone into this issue as to what is ultimately the end use of that product, whether it is for therapeutic purpose or other than therapeutic purpose, which is not the intent of the notification and under the manufactured drugs. So I fully agree with Tripti that this needs to be re-looked into and re-deliberated, and then come to a conclusion whether it is for therapeutic purpose or other than therapeutic purpose. If it is containing codeine phosphate only to a particular extent, whether it can be considered to fall within the NDPS Act or not, irrespective of whatever is a channel of distribution. Having said that, there remains one more question which was asked in this particular query, is that whether in case of a diversion by a distributor, whether the manufacturer will be liable. If the manufacturer is supplying the consignment complying with all the rules and regulations of the Drugs and Cosmetics Act, and the transaction is above board, and the manufacturer is in no way involved in the diversion, then just because distributor has diverted a particular consignment of codeine phosphate cannot be a reason to book and prosecute the manufacturer.
I fully agree with that, in the sense I think, and this is again something which is very important, that many of the enforcement officers, try to implicate the entire supply chain just because the source is from somewhere else. I think where the diversion is, the person is. There have been cases that I've seen, again, within an organization, a company that is there manufacturing a particular substance. There is a case of theft. There is a case of pilferage. Now, the people involved should be prosecuted, or the entire organization should be prosecuted. Now, this is something that needs to be distinguished, and I'm very serious about it, because that's one of the biggest pain points in manufacturing, distribution, and sale of such products. Now, obviously, from the eyes of the enforcement officer, he would like to book everybody involved, makes his or her life or the boss's life easier. But in reality, it creates a lot of impediment from industry to really get into these sort of products. And if industry is not going to make these products, now who's suffering here? It's the patients of this country who are being deprived of certain medicines. So I guess coming back to this particular point, I want to highlight that, the person who's responsible for diversion definitely needs to be taken to task. There's absolutely no question about it. But should it stop there, or should everybody be implicated till the manufacturer is something I would strongly object, and I would strongly recommend that should not be the case.
So in the eyes of the regulators, obviously at the initial instance, we do suspect all the members involved in the supply chain, but certainly during the investigation process, we'll come to know, and we'll specifically target who is the concerned person involved in the particular violation or the illicit traffic.
Sorry, 1 minute. All officers, enforcement officers should remember one thing: perceptions, misconceptions, prejudices are not substitute for evidence. You have evidence, hang the chairman of the company. But merely because somebody has pilfered the goods and you have suspicion, manufacturer, unless the chairman is involved, this cannot happen. This type of investigation does not befit the investigating officer.
Very true.
Well said, sir. So moving on to the next question, there are a few more questions, but I guess we are already past 30 minutes of the actual scheduled time. So I need the permission of the panelists to take up those questions or not. Or we can also send the questions if the time is not permissible for three of you. We can post the questions to your email and get it clarified.
I think you can take last two questions with permission from Devesh.
No, I'm happy to answer, because I think to get an audience like this, and I'm sure there are a lot of questions there, I'm happy to extend it if it's okay with Nambudri and Chipti. Maybe we can do it for maybe maximum 15 minutes.
Sure,
if that's okay with it.
Okay.
If there are so many questions, if there are no questions, we'll close it earlier.
All right. There are a couple of questions more or less related to the Drugs and Cosmetics Act and the guidance, and I'm not taking those questions at this point of time since our major discussion is on NDPS. Who is responsible person or the authority to provide the approval for destruction of a psychotropic substance?
It's under the Drugs and Cosmetics Act and rules. So whatever is prescribed under the Drugs and Cosmetic rules for destruction of a psychotropic substance, that applies. There is no other permission required from any other authority.
So they need not to go to the state licensing authority or CBN
No.
to get a permission for the destruction
No.
of the psychotropic substance.
No.
Clear-cut answer for that. And can alprazolam codeine formulation seized during a raid? Can we give an FIR under NDPS Act? If the alprazolam or codeine formulations are seized during a raid, then in that case, an FIR can be filed under NDPS Act or not?
Can you answer this, Tripti or Nambudiri? I don't want to take
Tripti,
this
please go
question.
ahead.
Sorry, what was the question? Alprazolam and
During a seizure, if alprazolam and codeine formulations have got seized, then the drug regulators can file an FIR under the NDPS Act.
I think both the products are under the NDPS Act, and if it is clearly a case of unauthorized possession without license, or like a large quantity, and you are only authorized to permit a small amount, then certainly the NDPS Act would apply.
Then the regulators can file an FIR under this NDPS Act. That's what you mean to say, that.
Yes.
But again, I think Tripti had mentioned earlier that sometimes I've seen that regulators seize alprazolam and this one because of a consequent issue down the line, like we discussed about the Distributors Act. They come to the factory, they seize. They seize the fact because there's an act somewhere else or by somebody else. They seize all the alprazolam or codeine formulations in a factory, despite the fact that the factory has a license for alprazolam to manufacture alprazolam and maintaining records. That seizure actually is not a seizure where you can actually should be prosecuting under NDPS because there's a license.
Yes,
And if there is, and I think she's also mentioned about Section 26, which is very less used. I would strongly recommend that officers use Section 26 because that's the discretion that they have. The discretion is that if it's a licensed premise and there is an act which is maybe say an administrative act that has happened, not maintaining a particular proper record or not able to show a particular document, the discretion should be used if the perception and the intent is clear that it is not for diversion. Then they should use Section 26, which basically entails fines. I'm not saying that you should let go the person, but there should be a fine. Of course, it has to go through a legal process for that. But Tripti had clearly said that is a section which is very little used. So I would encourage officers to look at Section 26.
So probably with the today's session, most of our colleagues start focusing more on Section 26 with these great discussions. And going to the next question. There is a question which is already answered.
Status of the essential narcotic drugs. Maybe we can answer that,
please.
because they should mention that though the act has been amended and new rules have been instituted, the scenario hasn't changed as much as it should have in terms of access for patients. And I would like to just point out two aspects here. One is that, often we think that if the regulations are sort of eased, like, some people complain that that was being done through the essential narcotic drugs. So that's not the case, but, there was a perception misuse will rise, there'll be more trafficking. But if you look at the statistics of the NCB over the last 4 years, that's from 2015 to 2019, you don't see any big difference in terms of morphine. So morphine is one essential narcotic drug, whose for access has been sought to be widely expanded. And there is no increase in morphine trafficking or illicit trade or diversion. So that's the first point. The second is that, as Devesh had mentioned, the essential narcotic drugs central rules are still not being uniformly applied across the country. So we had, through the Right to Information Act over the last few years, tried to get data from the state drug controllers' offices, because they are now the body to issue the RMI certificate and all the required consignment licenses, etc. And only 15 states had issued certificates to medical institutions to sell, stock, and dispense essential narcotic drugs. Only 15. So less than half were using it. And there was a great discrepancy from the data we found. A small state like Delhi NCT, had issued 184 certificates. And that's because, there is an active group of palliative care doctors, you have AIMS, you have other medical bodies who, use this, really bring this issue to the attention of the authorities. But a large state like Maharashtra had only issued 4 certificates. Now, this is very, very serious, because the number of patients in Maharashtra must be much more than the number of cancer and terminally ill patients, just the sheer size of the population in the state. So there is a serious problem here, and I know, apart from what Devesh mentioned, there were also some states that were saying that unless a GR is issued, government resolution, or order or memorandum, they will not apply the new rules. That is not the case. You don't have the choice. It is a central act. The state drug inspectors, that office is the authority, and you have to comply with the central act. We expect manufacturers and retailers to apply with the NDPS Act and the rules. I think the authorities should also apply and do what has been tasked to them in terms of processing applications and issuing the certificates to medical institutions.
In the case of END, unfortunately, the situation has been that due to pressure from some palliative care associations and industry associations, the 2014 amendment to the NDPS Act went through. There were amendments caused a special category of drugs called essential narcotic drugs was carved out from the category of manufactured drugs. And in fact, that amendment to the Act very clearly says that the entire power to control, regulate, and permit rests with central government and not with state government. So in fact, when Triti was talking about GR, I fully agree with her that many of the states are asking for a GR. Many of the state officers, state FDA officers are asking for a GR for implementing the amendments which have been caused to the NDPS Act for bringing this new category of essential narcotic drug. But in fact, the anomaly lies in the central rules. The central rules are in contradiction with the central NDPS Act. Central rules itself leaves a lot of scope for interpretation as to whether the central rules itself will apply or the state NDPS rules. My view is that the amendment which is required to be passed to implement the 2014 NDPS Amendment Act is to carry out sufficient amendments to the central rules and not to the state rules. The state rules as it exists today will continue to exist and it will not apply to END the moment the central rules are amended. The confusion lies in the central rules, not in the state rules.
So it seems there is a lot of debate needed to have a conclusion on this specific point, and we'll straight away go to those simple questions for which we get clear-cut answer from the panelists.
Another panel discussion, perhaps.
Yes, we might need almost a 2-hour panel discussion exclusively for getting these questions, I believe. I'm taking 1 or 2 more questions which are mostly related to the DNC and NDPS put together. So there are instances where most of our officers are facing like some of the tea stalls and daba and other general areas. They're stocking the huge quantities of codeine or other cough syrups. So in that circumstances, should we prosecute them under both the Drugs and Cosmetics Act as well as the NDPS Act? Or should we confine only to one particular NDPS Act?
I guess the fact that it is there in tea stalls and dhaba is not acceptable. By any standards, that's not acceptable, and that's a clear violation of the. But as the exemption provides, it should, and of course there is a Supreme Court judgment that Tripti mentioned. Primarily. Of course, you can apply, as I said, as Section 80 clearly gives, in addition to NDPS Act, the Drugs and Cosmetics Act and provisions also apply. So I guess action against both these ones can be taken.
And the last question I'm taking is that the procedure. Where one should apply for a destruction of an expired stock of fentanyl patches? Which authority that they should approach for getting a permission for destruction of this expired fentanyl patches?
Now, Mudri, would you like to answer this?
To the licensing authority.
But which licensing authority?
Whoever has licensed the manufacture of fentanyl patches, that would be the appropriate authority. Why I am qualifying or I am generalizing my answer is, there is a confusion as to whether preparations needs to be licensed by Narcotics Commissioner or by the state authority. See, if the licensing is by the state authority for manufacture of the fentanyl patches, then the destruction also has to be under the aegis of the licensing authority. Or on the other hand, if the manufacturing license is granted by the Narcotics Commissioner of the Central Bureau of Narcotics, then Rule 46 would apply. Rule 46
45A.
45A,
I think so. Destruction is 45A. 46 is maintenance of records.
45A would apply of the NDPS rules, and the committee would be formed by the officials of Central Bureau of Narcotics for the destruction of these patches. So my answer would be that whoever is the licensing authority, that authority needs to be approached for destruction of these fentanyl patches.
And just there is another level that if the patches are with a recognized medical institution, since fentanyl patches are part of essential narcotic drugs, and the stock at the medical institution, RMI, have expired, then that has to be, there is a separate authority, which is the state drug controllers for destruction. Yeah.
I think we have taken up most of the questions, and I apologize if we miss any of the specific questions are not answered. I request the audience to share these questions to unanswered questions to our email ID, and we will be happy to get the answers for those questions from the esteemed panelists. Now I invite our Chief Advisor, Dr. Deshpande ji, to extend the concluding remarks for today's program.
At the outset, I must thank Mr. Devesh, then Mr. Prasannan and Trupti Tandon for explaining in details the provisions, answering the questions with great patience. And I am sure the lot of confusion, the misunderstanding has been cleared off. And perhaps the officers will now be inspired, motivated to learn, study this act further, try and understand if there are contradictions. Of course, Devesh has highlighted the important provisions, the issues which always come up in the mind of officers. In my view, the today's take-home is study the facts in details. It would be advisable to get into the background, the object of the act, rather than interpreting provision by provision. A mere later interpretation should not be followed. The spirit in which the act has been implemented, has been framed, needs to be implemented in its own letter and spirit. Again, for the officers, their target should be whosoever is doing illegal activities, clandestine activities, deal with them with the iron gloves, but do not involve people on the basis of your misconceptions. So today's take-home should be investigate with open mind, collect evidence, and misconceptions, prejudices are not substitute for evidence. Understand the spirit. That's to conclude. I am extremely again thankful to the panelists, and thanks Devesh for studying from the perspective of the officers and then explain the things in a better way. Thank you so much.
Thank you, sir. And so with this, our officers are going to come out of their preconceived state of mind, and they'll start investigating with their open mind going forward. And I once again take this opportunity to extend our sincere thanks to Mr. Devesh and Ms. Priti and Mr. Nambudri for your patient answering all the questions and your kind presence for almost 2 hours. And we look forward to have more and more discussions with all of you in the coming months as per your convenient times. And we would be happy to collaborate with you and have more engagements in the future. Thank you once again, and thanks again all the audience for your patient listening. And we'll be sharing the presentations and the YouTube record session in our website, and the website link will be shared with all the participants via email. Thank you, and once again, and have a good day.
Thank you very much.
Thank you very much.